On Tuesday, July 30th, 2024, the Ashley Benefield trial continued and concluded with day 6. On day 6, the state put on a single rebuttal witness, and then the two parties gave their closing arguments, and the jury deliberated until around 10:30 or 11 p.m. to render a final verdict. And spoiler alert, here's what they ultimately decided. The jury acquitted Ashley on second-degree murder, but convicted her of the lesser-included offense of manslaughter. Now, I have tons of thoughts on what went on day 6 and where I think the defense maybe made some mistakes which cost them and could continue to cost them in their potential efforts to appeal. Let's get into it. Okay, so to start out, thank you for your immense patience while I got this final recap out. I definitely took my time on this one, partly because I wanted to really sit and think about this case and how it ended the way it did. And most importantly, I want to think of how it could have potentially had a different outcome. We often like to think that in every case, the side that wins is the one that has the better facts. But the truth is, there are also other factors that can come in and also influence the outcome. This is why, for example, I typically put such an emphasis in my trial recaps on the opening statements and the closing arguments, because although it is the evidence that should rule the day, the closing arguments and the opening statements can in fact shape how the jury focuses on that evidence. And in this case, I know that opinions varied widely on whether people thought Ashley was a true victim of DV or not. For my part, I did, and I still do at this point, think that she was a victim of DV. I also think that she was in reasonable fear of her life when she shot Doug. But obviously the jury disagreed with the way that I see this case somewhere along the lines. It happens. And when that happens, this is a great time to step back and figure out how that happened and what can be learned from the situation. And that's the thought that I really want to start off with, especially for people who might be disappointed with the outcome of this trial, and most especially people who are maybe DV survivors themselves, or are otherwise advocates for DV survivors, or are concerned with the way the DV is treated by the judicial system. One thing that really struck me is that in a case where the defendant is alleging battered spouse syndrome, or essentially a DV contextualized argument of self-defense, what they need, I think, most of all, is someone who understands DV on a deep level and who can communicate that understanding effectively to a brand new group of people and with a certain sense of empathy. I say this not to throw shade at defense attorney Neil Taylor, and I'm not saying that Ashley has some kind of a claim for ineffective assistance of counsel, for example, because I know that that's often a question that comes up in situations like this. He did a competent job, and although he made some missteps here and there, and I would argue he missed some crucial opportunities at the end. And as I always like to remind people, my job here in this video and in all of these videos is way easier than his job in the courtroom. I'm able to sit here and basically debrief this case or Monday morning quarterback it if you want to call it that. But meanwhile, he is the one who is put in the insane effort of putting on a case and putting on a murder trial. Rather, what I'm saying is DV defense cases, I think, are very difficult for a number of reasons. And part of that is because DV victims do things that are often strange to people who are unfamiliar with DV. And DV victims often have more trouble communicating their emotions and their thought processes coming out of these traumatic experiences, and most crucially, doing so in a way that properly advocates for themselves. After all, a hallmark of DV is that it typically involves some amount of psychological impact on the victim so that they can't actually see their situation properly and to be able to have confidence, to be able to walk away with confidence, for example. And so what a defendant really needs in a case like that is someone with more of a specialized understanding of it and who can also translate these things properly and on a more, emotionally savvy level so that the jury can fully connect with all the dots that are necessary for an acquittal. Okay, so with that said, let's talk more specifically about what actually happened on day 6. As I mentioned in the day 5 recap, the state was now going to have an opportunity for a rebuttal to the defense's case in chief. This is where they might introduce some new witnesses or perhaps recall some witnesses to respond to things that came out in the defense's case in chief that the state didn't have an opportunity to address in their own case in chief earlier. And because it's meant to simply respond to the defense here, it's really supposed to be limited in scope. And here, the state did put on a rebuttal and they kept it actually super short and sweet. Specifically, they recalled one witness witness from their own case in chief, and this was Eva Benefield. And here it was basically to just get 2 points out. First, it was to introduce a photo of Doug from August 2020, basically to show his stature from around the time of the incident and that he wasn't this big, imposing guy. And this was specifically to respond to a photo that the defense had introduced from, I think, 2018 or 2019 of him without a shirt and looking a bit more buff. So here, of course, the state wanted to show the jury, hey, this guy really wasn't so physically intimidating or menacing like the defense really wants you to think. Anyway, the second thing that they drew out of Eva was the fact that Doug was right-handed. And I didn't quite connect why they wanted to introduce that until it came up in the state's closing argument. So let's talk about the closing arguments. First, I want to talk a little bit about closing arguments generally speaking. Closing arguments are, of course, a bookend to the opening statements. Where I've talked about the opening statements being a bill of promises, the closing arguments are where each side shows how well they've kept their promises. Whereas in the opening statements, the attorneys are not allowed to argue. In the closing arguments, they are both allowed and actually really supposed to argue from the evidence. And when I say that, I mean the evidence that was actually introduced at trial. I'm going to say more about that in a minute when I get to the state's closing argument specifically. But before I jump into that, let me just say that the closing argument is where each side is going to want to connect all the dots of the evidence that's being presented so that the jury can understand where each piece of evidence was important. A really good closing will also package the evidence nicely into a story from their side's perspective. And the reason why story is so important is because humans really understand the world best when we look at it through a narrative context. It's one thing to go through all the facts that support your side in a closing argument, but it's quite another to be able to give meaning to those facts by highlighting them through a story format. Now, another thing that's important to understand is that the closing argument ideally convinces the entire jury to side with you, but in reality, that's not often how that works out. Instead, the closing argument by each side, generally speaking, is going to be aimed at the people on the jury who already support your side. The reason for this is because those are the people who are more likely to go into the jury deliberation room and continue advocating for your side on your behalf. So what the attorneys really should do then is package their closing arguments so that the supporting jurors can take the biggest points into the deliberation room and go from there. So that's closing arguments in a nutshell. What did the two sides do in this particular case? Let's start with the state's closing argument since they went first. So I'm not going to go over every single point that Assistant State Attorney Suzanne O'Donnell talked about in her closing argument. I think if you want to see that much detail, it's worth just watching the closing argument itself. One thing that I will say is that she went very hard after Ashley, and in a case where the defendant is alleging a battered spouse defense, that is fairly risky. In this particular case, it does seem to have paid off because, like I said before, the jury did end up convicting Ashley of the lesser included offense of manslaughter. But in the beginning, the state starts out talking about DV, saying that it's a terrible thing and that sometimes it does justify deadly force. However, she says there are two words that are very important in determining whether Ashley was acting in self-defense, and she says reasonable and necessary. And I will say, boiling it down to just those two words as to what is most important in this particular case is smart. Anyway, then she goes through the history of Doug and Ashley, and she actually seems to acknowledge that Doug did some terrible things in their past. She doesn't acknowledge that what Doug did was DV, but she basically says, yeah, we really can't defend the actions back from June 2017. And then she basically distinguishes all that happened back when Ashley was living with Doug in South Carolina to basically sever that time period from everything that happened in Florida. It was essentially all of that bad stuff that Doug did was in the past, and it stopped once Ashley left Florida. Of course, that narrative does ignore some of the evidence that came out from the defense side, talking about stalking and other things that were similar to that, but whatever. Then the state goes into how they say that that is also when Ashley started doing bad things against Doug through manipulation of him and of the family law system and even of the criminal law system. And then ultimately, when she realized that she wasn't going to get her way through this manipulation, she made the ultimate desperate decision, which was to, in fact, kill him. I will say, there were a lot of things about the state's closing argument that I personally did not like, particularly when it comes to ethics in the profession, and I will talk about that in just a second, but this was exactly what the state needed to do here in order to have a good chance of convincing the jury to convict Ashley. What I mean by that is particularly the severance between South Carolina and Florida. As I said in previous recaps, there are elements of the history between Doug and Ashley that simply cannot be ignored. There's the allegations of animal abuse, the act of throwing a loaded gun, the act of shooting a hole in the ceiling in the house in the midst of an argument, the act of punching a wall. Those are things that all had some kind of corroboration in some form or another. And so it's really hard to argue and say that those things didn't happen. And if you can't fight the existence of these events, you have to face the fact that these are insanely scary things for anyone to be on the receiving end of. So you can't just wave them away as if they're small things, because they are not. So really what the state needed to do here in the closing argument was to say, okay, yeah, there were some bad things that Doug did in the past, but that was 3 years before any of this happened. And he spent that entire 3-year period trying to make up for it. And what he got was death. And so that's exactly what the state did. And they did that by crafting the facts into a comprehensive narrative that told the story through this particular lens. They also did this by using the Duluth power and control wheel to point out all the things that didn't apply to Doug and Ashley's situation in that period of 3 years. This, like I said, was also very smart. Now, I have all kinds of disagreements with how they use the Duluth power and control wheel, but hey, that's a tool that they had at their disposal, and they used it in a light that was most favorable to their case. And along the way, they repeated the same theme that they had before. And that was, Ashley's a manipulator, and she manipulated Doug, and she tried to manipulate the system, and she tried to manipulate the police, and she tried to manipulate the judge by getting the police to arrest Doug in front of the judge, and so on, until the conclusion was, and now, ladies and gentlemen, she's also trying to manipulate you too. O'Donnell talked about how Ashley was shedding fake tears, which I know has been a point that people who favor the state in this case have been pointing to. Personally, I do have issues with that kind of an argument, because I think that there's a distinction between having a grief response to something and a trauma response to something, particularly in the context of PTSD, and those two can look very different. For example, if someone is in the grips of a PTSD episode, they might be hyperventilating and not have any tears whatsoever, and it might be incredibly real for them. So while I understand that in a sense it's fair game, at the same time I have some issues with going so hard on the defendant in this way. But that's not the part that really got me worked up in this closing argument. Rather, it was the state's series of misrepresentations and sometimes all-out lies about the evidence in this case. For example, one of the smaller pieces of misinformation was when she said that he filed for divorce, implying that he was the first one to do so. Although she technically didn't lie about it, the implication was that he in fact was not obsessed with Ashley, but that looks a little bit different when you realize that Ashley was in fact the first one to file for divorce. This one, I think, could and should have been emphasized by the defense in response. However, that was a pretty minor thing, and you can kind of get away with that with a little bit of the gray area because it's more implication than anything else. But there were other things that the state said which were 100% things that the defense should have objected to on the basis of facts, not in evidence, because they were egregious misstatements. For example, the state said in their closing argument that Doug filed for a petition for full custody of Emerson. That was something that never came into evidence, so it's absolutely inappropriate to reference it in closing. She also said that Ashley told Dr. Broder privately that she wouldn't move in with Doug in Maryland, but that when Doug was with Ashley and Dr. Broder, that Ashley would affirmatively say she was moving in with Doug. That second half of that sentence was never testified to by anyone. Rather, Dr. Broder testified that Ashley would basically deflect the topic whenever it came up to say basically, well, we can talk about it later. That's not the same thing as saying, yeah, we're moving in together. So to that one, I would have objected because that's misstating the evidence. Now, on another note, the state also said that Bruce Ferris, the DV expert for the defense, said that once someone is violent, they're always violent and nothing can be done about it. But that's not what Bruce Ferris said. Mr. Ferris said that once there's violence in a relationship, it's almost impossible for that relationship to recover. He also said that he treats patients regularly who are both abusers and victims, and that he therefore works with people with these kinds of behaviors. Essentially, what he meant was a person can be rehabilitated moving forward, but the relationship in which that violence occurred probably can't. In other words, the aggressor can make themselves better for the next relationship, just not the damaged one. And to me personally, that just makes a lot of sense. But anyway, probably one of the most material misrepresentations the state made in their closing argument was about Dr. Quintal. Now, what was so powerful about his testimony in particular was that he served as an objective observer and came to the conclusions about Doug being controlling and aggressive. But the state, in closing, said that all of his opinions were from conversations that he had with Ashley and that this was just another Ashley manipulation. That simply is not true, since he testified that he also had conversations with Doug and that his conclusions also came from observing them together. And I'm going to go into some more detail about what I think the defense could and should have done differently in their closing argument. But the big mistake that the defense did here was in not objecting to these things, particularly on the more egregious ones, like Doug filing for full custody of Emerson, because that just 100%, no one talked about that. We have no idea whether that's true or not. And Dr. Quintal basing his conclusions only on what Ashley told him. Now, I've talked before about objections during opening statements and closing arguments and how, generally speaking, they are kind of frowned upon. And this is because they can be viewed as a tool of gamesmanship. Like one side is just trying to unfairly mess the other one up. It also can just look that way to the jury as well. This can look to them like desperation, which also isn't really a good look. So you've got to be careful with objections during these times in the trial. However, there are times when one side absolutely needs to object because the other side is saying or doing things that are totally inappropriate, and it can end up confusing the jury. And in this particular case, there was evidence that the jury, in fact, did get confused by at least one of these misrepresentations. And so this is where the judgment of the objecting attorney is crucial. If you're going to object, you generally want to make sure that you're right about it. This way, you either win on the objection because the judge agrees with you, or you at the very least preserve it for an appeal. And here, all of this is exactly why the defense needed to object when the state misrepresented the evidence to the jury. Okay, so that's the state's closing argument. What about the defenses? So Neil Taylor did okay in his closing argument, but I really think that other than not objecting to the state's misrepresentations in their closing arguments, he made some missteps in his own closing. Let me first mention some things that he did well, though. When I watched the state's closing argument, I remember watching to see if they talked about Dr. Broder and his report at all. And this is because I remember that in the opening statements, the state made a really big deal about the Broder report, saying that the whole reason why she killed Doug was because she didn't want the results of that report to ever get out. And in the closing arguments, I noticed what Taylor ultimately noticed as well, that the state completely moved the goalposts on what they said her motive was. Like I said, in their opening statement, they said that the motive was that Dr. Broder's report was coming out, and so she wanted to prevent that, and that's why she killed him. But even as early as Ashley's cross-examination, they seemed to emphasize that a little bit less. And lo and behold, in the closing argument, they said nothing about the Dr. Broder report and said that now her whole motive was to prevent the hearing about her own injunction from happening. And to his credit, Taylor seized on this. He also did point out that the state made misrepresentations to the jury. However, I would have done this differently myself. Now, granted, like I said, I am Monday morning quarterbacking here, of course. It's always way easier to say I would have done this or I would have done that, especially when we already know how things actually ended up going. And like the best closing argument is the one that's written after everything is said and done, of course. But I can't help but think that I really would have liked to see the defense really seize on this harder and right up front. For example, I don't know, it's just me. The first line I would have wanted to hear from Taylor in his closing argument is something along these lines. Ladies and gentlemen of the jury, the state just got up here and accused my client of trying to manipulate Doug, trying to manipulate the police, and trying to manipulate the system, and now trying to manipulate you. But throughout their closing argument, the state just made a series of serious misrepresentations to you. In fact, some were outright lies. And so I would like to know who's manipulating whom here. And then I would just go down the list, like a checklist of all the things that the state said in their closing argument that was untruthful, either by omission or because the state was outright lying to the jury, and then pointing to the parts of the testimony that say otherwise. I would really try to keep this snappy. And then with each thing that they got wrong, once you finish mentioning it, then say, okay, let's talk about the next thing that they got wrong. And then the next thing, and then the next thing. Look at this laundry list of things that they just lied to you about right through their teeth. This is different than the way that Taylor did it because he kind of dragged after he pointed out that the state had said some wrong things. And I think in doing that, he ultimately lost the jury's focus, and the importance of those points that they got wrong were sort of lost as a result. And so it could very well be that the jury ended up looking at that and said, okay, so they got some things wrong, but were those really important? I don't know. Now, I think that one of the biggest mistakes in his closing argument was that although he went through the facts, he didn't tell those facts in the framework of the story from Ashley's perspective. Remember, like I said, humans are like narrative creatures. Storytelling is how we understand the world best. And this is why like the best YouTubers, for example, are the ones who really succeed at the ultimate peak. They tend to be basically just really good storytellers, sometimes in different formats and using different narrative tools. And the same thing is true with trials. And in this particular case, I think the state ultimately ended up with a serious advantage over the defense precisely for this reason. However, probably the biggest mistake that the defense made in closing arguments was to focus a little bit too intently on things that the jury just wasn't going to care about much in deliberations. For example, he ended up spending a lot of time talking about the whole Stephanie Murphy, Faith Brown situation. And I said in an earlier recap that all of that was likely to be a little bit too confusing and even administrative for the jury to really be able to hone in on its importance in this case. While it was a point scored for the defense because it was getting to the issue of what that hearing was about and whether that hearing really could have been the thing that Ashley killed Doug over because she wanted to prevent that from happening, it really was never going to be that crucial of a point that the jury was going to care about, in my opinion. And I think Taylor also spent too much time talking about Detective Gillum and what he knew about the South Carolina injunction at various points in time. That simply seemed like it was just too remote from the issue of whether Ashley was in fact a DV victim and whether she used necessary force because she reasonably believed that her life was in danger. And that brings me to where I think Taylor should have placed the primary focus of his closing argument. Going into it, he had to have known that the greatest weakness in the defense's self-defense argument was the fact that Ashley was in Florida for those 3 years, for the most part separated from Doug, while he technically was living in South Carolina. The state has been working to exploit that weakness throughout this entire trial. And so at the end of the day, what the defense really needed to emphasize to the jury in closing arguments was twofold. First, he needed the jury to be convinced that Ashley was in fact a victim of DV and that Doug was her abuser. And second, the defense needed the jury to be convinced that this led to Ashley being in reasonable fear for her life on September 27th, 2020, and that the force she used was in fact necessary. Now, the strongest starting point for all of this is the June 2017 gun incident, because like I said, Doug's actions there were totally indefensible. Even the prosecution had to sort of walk that back a bit in their closing argument. And another piece that the defense had at their disposal here for this argument then was the idea of patterns of abuse and how a DV victim will recognize when a new cycle of abuse is starting and they'll modify their behavior into compliance accordingly. This meant going back to what Mr. Ferris explained about cycles of abuse and forms of coercive control. And this would have been an excellent time to respond to the state's really misuse of the Duluth power and control wheel in their closing argument. And by that I mean Taylor could have, and I think really should have, pointed out that this wheel isn't meant to be some formula that says that there's DV if you have all of these factors present. Rather, it's a series of factors that can indicate an abusive relationship. Mr. Ferris never said that you needed something from every single portion of this wheel in order for there to be DV. Rather, he said that if you see a pattern of this behavior by person A over here, and you see that what results is that person B is put in perpetual fear and therefore starts walking around on eggshells around person A, then we probably have a DV situation. So I would then turn to the jury and say, look, the state's conduct of cherry picking these various parts from the wheel indicates that either they don't actually understand how this tool actually works, or they are willfully misrepresenting that information to you. But anyway, what Taylor really needed to do here, I am personally convinced, is to point out a pattern of behavior that happened in June 2017 and to show the jury how the events of September 27th, 2020 echoed the very same pattern. This is how he needed to play up the significance of the June 2017 incident, where the state tried to play it down. Because if you can show that even 3 years later, an abuser starts showing the exact same pattern of behavior that in the past led him to throwing a loaded gun at or even near the defendant and punching a wall and shooting the ceiling, and then you say, well, the only difference on September 27th, 2020, as opposed to the June 2017 incident, is that now he even feels bold enough to strike her in the lead up to wherever he's winding up to go. That's where you actually capitalize on the fact that Doug never hit her before that day. So whereas the state was using that point as a serious weakness in the defense's case, the defense is taking that and saying, no, this actually supports our case. Because if he never hit her before, but ended up doing something so indefensible as the June 2017 incident, something so indefensible that even the prosecution had to walk it back and acknowledge that it was a really terrible thing to do, you can then turn to the jury and say, ladies and gentlemen of the jury, imagine where Doug's escalation was going to go on September 27th, 2020. And make no mistake about it, Ashley did not forget this June 2017 incident. She spent the last 3 years trying to make sure nothing like this ever happened again, by trying to call the police, by trying to get injunctions, by trying to divorce him, by trying to ensure that he never used Emerson as a tool against her by harming Emerson. And so having remembered what happened just 3 short years before, yeah, of course she was afraid, and of course her fear was reasonable. And was that force necessary, ladies and gentlemen of the jury? He chased her through the house and didn't even stop when she warned him by pulling a gun in front of her. And then he continued to pursue her. That's a bit of the argument that I probably would have wanted to make if I were the defense attorney here. And then I would have gone through Dr. Haig's testimony to show how the forensics actually lined up with Ashley's account and how it showed that the initial gunshots were closer to the doorway and that Ashley was still trying to back up by moving from the right to the left into the corner of the room. I would have used his 3D modeling to show this and to link it up with Dr. Liu's testimony about the ordering of these shots. I would have even used the fact that Doug was right-handed, by the way, because the state did a great job of using that to show why Doug would initially have his right arm and his right leg farther back in something of a more like a waiting stance. But the fact that he was shot on the right/front side then only supports the defense even more, in my opinion, because that lines up exactly with someone who got shot when he had already lunged forward, because he would have then pivoted with his left foot and stepped forward, leading with his right side. It also lines up with Dr. Liu's testimony that his arm grazed by that bullet ended up down the hallway, which again also fits the idea that the first shots were closer to the doorway and that Ashley was in the process of trying to back up as she continued to shoot Doug, who continued to move towards her. And I also would have highlighted Dr. Liu's testimony in this moment about the chest wound bullet nicking Doug's spine and how that also fit into this whole series of events. Then you have the ordering of the gunshot wounds lined up through Dr. Liu's testimony, along with the forensics from Dr. Haig about Ashley's movements from right to left. And all of that fits along with Ashley's testimony about what she says happened. Because then what you do is you create this large picture made of these individual puzzle pieces, and you say the state is trying to discount this piece or that piece or, whatever for their lame reasons, but you can't deny that all of these pieces just happen to fit together perfectly. And personally, I think that is how you use all of the facts in this case to make a more convincing closing argument. Then again, maybe I'm just like a victim of the IKEA effect right now. The idea that we love our own ideas because we're the ones that came up with them in the first place. Maybe you're not convinced by my proposed changes. Maybe you think that the defense still would have lost either way. Maybe you don't think that this is any better than what Taylor actually said in his closing argument. Either way, let me know what you think in the comments down below. Anyway, now for the state's rebuttal. This was given to the jury by O'Donnell's co-counsel, Rebecca Friel. So keeping in mind the fact that, yes, the state ended up securing a conviction, let's just say I don't think that the state's success came from this rebuttal. When we talk about rebuttals, the whole point of them is to provide the state an opportunity to respond to points in the defense's closing argument that weren't already really addressed in the state's substantive argument. Both sides do get the same amount of time, but because the state goes first, they do have this option of reserving some of their time for the very end, just so that they have the opportunity to give that sort of a limited response. And while the state can really choose how much time they end up reserving for the rebuttal, generally speaking, the idea is that you want to use most of your time in the substantive closing in advance, usually. Anyway, I don't really want to spend too much time on the rebuttal other than to make a few points. Personally, I didn't think it was particularly strong, unlike the substantive closing that the state did give, although it did reestablish the narrative that Ashley is a manipulator who has attempted to manipulate everyone along the way to get what she wanted, and that she's now trying to manipulate the jury. Personally, I think that her logic about the manipulation actually seemed less convincing than the way that her co-counsel laid it out in the substantive closing, but hey, that's just me. However, her rebuttal seemed to ramble a bit and it felt somewhat disorganized, which made it a little bit harder to follow at times. She also said some things that I thought were objectionable and really should have been objected to. One of these was where she talked about Dr. Liu. And specifically, she brought up the fact that Dr. Liu is a paid expert. And she said that this is why Dr. Liu has testified a bunch of times on behalf of the state before, and it's why now she's testifying for the defense. Essentially implying that she's being paid to give a specific kind of an opinion and that she's influenced by the fact that she is being paid. Now, normally this could be a totally fine argument within the bounds of what's proper in trials. And it most likely is the case that Dr. Liu was indeed an expert who was paid for her time in this case. However, this was something that never came up in testimony. And so this was yet another thing that the state brought in for the first time in their closing argument. And what's even worse is the fact that this is coming up not just in closings, but for the very first time in this trial, it's coming up on rebuttal. And so if I were the defense attorney, I would absolutely want to object to this as facts, not in evidence. And I would make the case to the judge that this is a big problem because the jury doesn't necessarily have enough information to understand what it means for an expert to be paid, specifically that she's paid for her time and not to give a specific opinion. I mean, if you've watched a number of trials by now, surely you know that. Generally speaking, this point that comes up on cross-examination about an expert witness being paid is really more of a nothing burger than anything else, because then on redirect, the other side gets up and kind of clarifies, like, okay, what does that actually mean? But in this particular case, for all we know, these jurors have never set foot in a courtroom before their own jury selection process for this particular case. So that's a prejudicial statement to just throw at the jury without context and, more importantly, without giving the defense an opportunity to respond. And so I would argue to the judge that if the state had chosen to bring that up on cross-examination, on rebuttal, I could have gotten up and clarified for the jury what it means for the expert to be paid. But because the state didn't do that on cross, the defense didn't have an opportunity to respond and contextualize. And what's worse, they didn't even bring it up in their substantive closing. They brought it up in their rebuttal, which was after the defense has no more opportunity to say anything to the jury at all. So this is an even dirtier move, in my opinion. And there's another thing from this rebuttal that just irked me, rubbed me the wrong way about Rebecca Friel in general. This was admittedly just a very small thing, but it felt so petty and it just annoyed me, and so I want to talk about it. When she talked about Bruce Ferris and the Duluth Power and Control wheel, she did something else that she also did on cross-examination with him. I noticed it then and I kind of rolled my eyes at it because it felt a little forced, but then I let it go because, I don't know, maybe it wasn't intended. At one point when she was cross-examining him, she addressed him as Dr. Ferris. I mean, Mr. Ferris.
Good morning, Mr. Ferris.
Good morning.
Mr.
Okay.
Oh. I want to ask you some.
And to me, in the moment, I was like, was that a jab at him for not having a PhD? She didn't do anything after that to confirm that she was just being petty, but there was this part of me that was I don't know, she could have just pointed out that he doesn't have a doctorate degree in any of this. When it comes to expert witnesses, it's totally fair game to poke holes in their credentials even after they've been qualified as an expert. And that's because that kind of a line of questioning goes to the weight of their testimony. So she could have just asked a line of questioning about it. But like I said, that comment wasn't followed by anything that seemed to confirm that she was being petty. So, I basically kind of let it go. But then in her rebuttal, when she was talking about Bruce Ferris, she did the same thing and in the same way.
And that brings me to Dr. Ferris. Mr. Ferris. Mr. Ferris has never seen a relationship he wouldn't say is a domestic violence relationship.
And to me, it just seems like, I don't know, maybe she just has a habit of mixing up Mr. and Dr. for all kinds of people all the time. You know, like during the Karen Reed trial, I could not for the life of me keep Aruba and the Bahamas straight for some reason. I kept wanting to call the Aruba incident the Bahamas incident. But in this particular situation, it does feel like this was intentional, really. I don't know. To me, it just felt like she was being snide when, again, she could have just talked about his credentials and how she felt that something was missing from them without just, I don't know, looking so like Mean Girls-ish. Like I said, this was such a small thing and it just irritated me personally, even though I highly doubt that it really registered for most people, or maybe anyone for that matter. Anyway, after Friel's rebuttal, Judge White went through the jury instructions with the jury and then sent them off to deliberate. And the jury ended up staying until like 10:30 or 11 o'clock at night to render the verdict of guilty on manslaughter. Before they got there, though, they first came back with a question for the judge about whether or not Dr. Quintal had based his entire opinion on Ashley Benefield's testimony. And if you remember, this was one of the things that I think the defense really should have objected to. Because as it turned out, the misrepresentation by the state on this point did in fact end up confusing the jury. So if the defense had objected and say the judge overruled the objection and then this question came out of it, this would have been decent grounds for an appeal in my opinion. And now the judge had two options in responding to the jury question. Either tell the jury that they had to rely on their own memory and that's it, or do a readback of the transcript from the testimony. If I were the defense, I would absolutely have wanted the transcript to be read back to them because this would have shown the jury for themselves that the state did in fact lie to them in their closing arguments. And it would have reestablished Dr. Quintal's testimony, which was really good for the defense. However, Judge White ended up just basically telling them to rely on their own memory. So everything that ended up coming out of this could have been a stronger argument for an appeal, but the defense's failure to object during the state's closing argument weakens that argument for a potential appeal. Anyway, much later, the jury came back and said that they could not agree on the charges. This was somewhere around like 9:45 or 10 p.m. already at this point. They apparently indicated that they wanted to continue deliberating rather than coming back another day, even when given the choice, and so they were sent back for more deliberation. Something like 30 or 40 minutes later, they came back with a guilty verdict on the lesser included offense of manslaughter. Now, I know a lot of people have said that this was, the jury that wanted to stay late, and also that this is something that happens all the time in trials, and so therefore all of this was totally normal and totally fine. Now, for both of those justifications, I really don't care. Staying late after court hours is one thing, but staying late to an hour when most people are really going to sleep is something else. When we are talking about a case where the ramifications of the decision either way are as big as they were in this case, I personally think it's best that the jury finalize their decision when they're likely to be thinking clearly. It's not just about what the jury wants to do. It's also about what the jury is reasonably and responsibly capable of doing. And what troubles me about the late hour of the verdict was there were indications from the jury that they didn't want to come back the next day, or some of the jurors had some scheduling issues the next day. And so I worry that the reason why they wanted to just stay later and kind of come to a conclusion wasn't so that they could actually reach the conclusion for the right reasons, but rather because they just didn't want to come back the next day. And there was an indication that the jury couldn't agree less than an hour before the verdict ended up coming in. And so when they came back with the conclusion that she was guilty of manslaughter, this just felt like they were coming to an agreement, not because they agreed substantively that this was the correct conclusion, but rather basically to compromise and be done with it and go home and be done with this whole trial. Now, of course, this is me talking about what I think happened based on what my gut is telling me. Unless jurors choose to talk openly about exactly what happened, no one can really inquire as to how they reached that conclusion or why they reached that conclusion. This is because in the US, we have a very strong policy of protecting the jury deliberation process, and for very good reasons. But did this verdict raise an eyebrow for me? Yeah, it did. And I don't care if this is common practice in courtrooms, by the way. The idea that they were there so late in the night on the first day of deliberations. To me, common practice is never a great justification on its own. Just to highlight that point, there have been other common practices in courtrooms in the past that we simply do not allow anymore. As an example, in SA cases, it used to be common practice for the defense to question a victim on his or her, usually her, sexual history prior to the incident. The idea was that if she was promiscuous before, then there was a pretty good chance that she was actually consenting to the activity this time. Now, today, we recognize this as impermissible character evidence. I mean, we understand that just because she's consented with other people, possibly, or even with this person at other times and under certain circumstances in the past, that doesn't mean that she consented at this time with this person under these circumstances. Logically, that makes perfect sense, of course, and is the same reasoning for excluding any other kind of character evidence in trial. And yet, it used to be a common practice. So like I said, common practice in courtrooms isn't really a great argument that works for me personally without something else to really supplement it and give actually a better reason for its continuing existence. Anyway, now there's the question, what's next? Well, there will be a sentencing hearing for Ashley where we'll find out how much time that she will end up spending in prison. Regular manslaughter is punishable by up to 15 years in prison, 15 years of probation, and a $10,000 fine. Aggravated manslaughter, on the other hand, is punishable by up to 30 years in prison, 30 years of probation, and a $10,000 fine. And because there was a firearm involved in this particular killing, we are actually talking about aggravated manslaughter here. And from what I've researched on the sentencing for aggravated manslaughter in Florida, it looks like this is a level 8 offense. And this means that if there are no grounds for a downward departure sentence, then the required sentence that the judge has to give Ashley is a minimum of 11 and a half years in prison. Downward departure grounds are basically mitigating factors that, if proved, can reduce the minimum sentencing a little bit further. These include factors like the defendant willingly entered a plea agreement, or they were an accomplice and a minor participant in a crime. Or maybe the victim of the crime was an initiator, an aggressor, or a provoker of the incident. Now, the list of mitigating factors highlighted in the Florida Criminal Procedure Statute apparently is not an exhaustive list. The judge could also bring in other factors here. So when it comes to sentencing, it'll be interesting to see if Judge White ends up bringing in factors like the fact that Emerson now is going to be essentially parentless for her entire childhood, or things like Doug's history of violence or aggression against Ashley through things like the June 2017 gun incident. Either way, this is largely going to be up to Judge White. So expect to hear his real thoughts on this case and about these various moving pieces. It'll be interesting to see, that's for sure. But anyway, those are my thoughts. What do you think? Do you think that this was the outcome that it should have had? Or do you think that there should have been a different outcome? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next one is out there. And if you're really loving the content and you want to know how to best support the channel and get perks like early access to non-trial recap videos, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next video.